Friends, we are starting now. Today is the 234th Friday group meeting. The topic is Bolar Exemption, how good defense in patent infringement cases. The speaker is our beloved friend and prominent Friday group member. She came all the way from Bombay. Dr. Dhanalakshmi S. Krishna-Iyer. Rest of the things Madhu will give. She completed Ph.D, LL.B, LL.M, specialization in intellectual property rights and registered patent also. I request Madhu Yadav will say a few words about Madam.
Good afternoon and a warm welcome to all the esteemed members of the bar. Today, I am truly honored to introduce and review the CV of a remarkable legal and scientific expert, Dr. Dhanalakshmi S. KrishnaIyer. Also, I extend my heartfelt thanks to our respected Sheshagiri Rao sir, the organizer of the Friday group, for providing me this opportunity and bringing us all together. Respected Dr. KrishnaIyer ma'am stands as a testament to excellence in both the legal and scientific arenas with over 2 decades of experience that spans a diverse range of fields which includes human rights, constitutional law, intellectual property rights and land laws. As a practicing advocate in High Court and Supreme Court as well as a registered patent attorney, Dr. KrishnaIyer has profoundly impacted civil, criminal and intellectual property law. Her academic accomplishments includes an M.Pharm, Ph.D, LL.B and LL.M, which reflects her commitment to both rigorous study and practical applications. From her extensive work in litigation and preparing litigation matters to her scientific roles in the industry, Dr. KrishnaIyer's career has been dedicated to both justice and innovations, known for her work with patents, trademark, copyrights and industrial designs. She brings a wealth of expertise that serves not only clients but also the broader legal scientific communities. She has also been appointed on panel of assistant government pleader and additional prosecutor in High Court, in income tax and also in legal aid. Apart from that, ma'am has also given a couple of reported judgments. And apart that, the most important is her published books, which includes highlights on pharmacovigilance and the another one is Indispensable Vector of Law, a comprehensive analysis. Her contribution as a guest faculty member, published author and a speaker further highlights her commitment to knowledge and sharing nature. Today, as we dive into ma'am's journey, let us be inspired by her achievements and the immense dedications. Once again, thank you ma'am for joining us in this session and enlightening us and making this session knowledgeable and memorable.
Good afternoon, friends, and thank you very much for a warm welcome. I'm really glad to be a part of all of you and to address on this particular topic, which seemingly seems to be a little bit, definitely flooded with a lot of complexities in terms of a lot of litigations that went ahead after 2005 when the product patents came into picture and role in India. When we actually talk and say probably consider and deliberate on this called as a Bolar Exemption, this particular Bolar Exemption or an exception wouldn't have arisen if not for the case where the generic medicines and innovator companies would have had a tiff. So there was an ongoing tiff between the innovator and generic companies constantly. This is just for a backdrop so that at least some people would understand the context of what Bolar Exemption would be like. Because here we are going to cater to a lot of things like patents, the patentee rights, compulsory licensing, Bolar exemption in terms of the exception that's carved out, under Section 107A of the Patent Act. Now, in this particular scenario, like what I would like to say is like there were generic companies and innovator companies who were on loggerheads, because innovator companies here would shell out a lot of money in terms of research and development. So a lot of investment goes into it, like $1 million investments. And then what happens is, because of this patent statute, which is present everywhere globally in all of the countries, dependent on what the national policy would be like, the tenure would vary. That is, the patent term would vary. So the patent term would be different for different countries, and depending on that, they would actually take a call on policy decision making. While this was considered, what happened is there were companies in US who were already in terms with product patents. There are two things. There are product patents and there are process patents. And this is very necessary because the Bolar exemption, although 1078 does not categorically talk about only pharma patents or medicines or healthcare sector, I'll read that out. There is 107A and B considering parallel importation, and one where you are actually giving information for regulatory approvals. So although the language of 107A is not really oriented towards talking about, you're only going to talk about pharmaceutical medicines or healthcare, but that became prominently so more important, because then actually granting to step into a market, to put a foot into the market, to have a hold there, and also to see to it whether you're not infringing on a patent, because patent became so predominantly important. Are you going to infringe on a patent or not? Also was very, very important. And considering all of these aspects, it was very necessary to strike a balance between your innovation and the third party rights, the patent owner rights and the healthcare. So the healthcare system and the public policies had to be carved out in such a way, and hence the statute had to be amended to that effect. So when we talk about the statute being ought to be amended, it arose out of one of the US Congress reactions in one of the US Federal Circuit appeals of Roche versus Bolar case. I'll read that out, where it was said that the experimental use cannot be conceived for a limited purpose of a patented invention. And hence it triggered a whole lot of chaos in terms of then you're trying to say that, because there are exceptions and defenses to patent infringement, where you on one hand talk about a lot of parameters where you have many defenses in per se the patent infringement. On the other hand, you have like a set of it, and then you have only this particular thing called as the patented invention in terms of a Bolar exception. So an exception being carved out. So why are we not concentrating on that more? Because those are the normal defenses. Whereas when it comes to a Bolar exemption, Delhi High Court, I think Supreme Court has ruled out a lot of judgments in terms of rolling out on the litigations, as I said, post 2005, where it became very necessary, very, very, very important and pertinent to note that yes, 107A plays a major role, and we need to see to it that we are balancing out legitimate interests of both the parties. And considering that we are trying to say innovation needs to be boosted as well as competition needs to be boosted, as well as you need to concentrate on the price restoration, which means Hatch-Waxman Act. So I was talking about the Roche versus Bolar case, where there was a triggering reaction there. And then US Congress took a call that they have to amend the legislation to the extent of including a particular statute called as the Hatch-Waxman Act or the Drug Price Restoration Act. So what does this say? And in Indian scenario, it is called as ANDA, the Abbreviated New Drug Application Filer, where you have ANDA 1, 2, 3, 4. It's not very important for all of you. I would try to keep it as simple as possible. Now, when we talk about what happened in Roche versus Bolar case, because of this, the Bolar exception was carved out. So there was a Hatch-Waxman Act, and Bolar provision was included. Considering this, every other country took a call on it, Canada included. Indian regime is equivalent to what is there in the Canadian regime. So 107A, although it talks about, then of course it drove in all the more of controversy. So this is where the Bolar exception came into picture and role. So I hope we've got a gist of it. Now, when we talk about a lot of cases which flooded in the courts and the circuits, were actually trying to dispute and deliberate a lot in terms of the quantity exported, because I'll tell you what that means. Because majorly, let me just give you a gist of what patent rights are. Patent right, or a patent holder, when we say he has a right, we must say that it is not a positive right, it's a negative right. It's a negative right in terms of a monopoly right. So the monopoly right is trying to exclude all other parties and third party to stop in terms of make, use, sell, offer to sell, and importation of the drugs. So this is what, although the statute does not categorically talk about what are infringing activities, but at the same time it would say that patent rights are catering to all this, hence you shouldn't be violating that. So it's not clearly and categorically spelling out that these are the infringing activities. So now when we come to this aspect of patent rights being these, so categorically we'll have to talk about an amendment which was made to that effect in terms of carving out an exception to 48, which is the rights of the patentee. After a patent is granted, the patentee right starts. And I'll read that out also, because that's very important to understand how Bayer Corporation, how Merck and Sharp Dome, this particular company, in terms of in terms of NATCO also, that there was a conglomeration of your CL, that is compulsory licensing in terms of section 84, 90, 92, and also we would take the Bolar exception into consideration, and how very smartly and thriftily, of course, then I have my analysis per se that where probably it could have been done in a different way, but then they came up with a lot of things like what is the quantity, because now you know import. So what was the arguments rendered by the councils is that, look, if we have those sections in the Patent Act like 84, 90, 92 and all, which talks about exports, 107A only talks about import. Why is that so? That means when it was talked about regarding 9 kilograms or 800 kilograms, which is amount tantamount around 3 crores of the product being exported to a different nation or a country, all of these nations and every in nations where the intertrade happens, I'm talking about that, where we are talking about the quantity, then why is selling attributed to? Because then the legislation would have been cautious in putting in export instead of import, because it is exports in all other section. Why is it not an import in the 107A? And hence they were trying to use that for the benefit in terms of defense, that if it is not categorically mentioned as import, legislation never intended it, is what they were trying to say. So because then the court tried to trash it out in terms of saying that no, it is also in terms of versus US, United States and Indian statutes, if you take togetherly and try to compare both of them and the aspects of it, it would be very, very clear in terms of US saying only in their jurisdiction. Now, because patent also, we'll have to understand that territorial jurisdiction is very, very important. Because when we're talking of the monopoly rights, I was saying that it's an exclusive negative right, that you're trying to stop others doing it, and hence it is a right for you. So we'll have to bear that in mind. So now when we consider this particular aspect of US saying that no, I'm trying to limit it, or we as a nation is trying to limit it only to the US sector or US domain, Indian statute talks about what? Any other countries. And hence it was actually read with this aspect in this statement, which was included in section 107A. Read this with read this. That means it was not just related to in terms of import, it was also export. They had to actually also, there were certain arguments rendered by the council saying that the dictionary quotes what sell and what does sell mean. It is not including territorial jurisdiction at all and all of that. So we'll come to that. And hence I would say that later on court just tried to say and try to convince, and of course an order came through saying that selling includes, export includes selling, selling includes export, vice versa. So when you're trying to sell it to a different country, nothing is prohibiting you from doing that, because the legislation is clear about it. It's not mum about it. And hence this particular aspect was thrashed out voraciously, and then they came to a conclusion that yes. Then reasonably related is another aspect where the courts and the councils deliberated on this issue of what does reasonably relate mean. Coming back to this one more aspect which I really want to enlighten all of you, is that when we talk about the monopoly term, The monopoly term is for 20 years. So, it's good amount of. Now, because now I was also appearing before the Intellectual Property Office, which I'm not doing right now, but I know that examination of a patent and everything also takes its own sweet time. It gives you a very, very broader range of like within 4 years, within 2 years. Of course, what comes from the Intellectual Property Office is not really limited to the number of years, but it is with the respect to the inventor that they need to finish it off in these many years. But it is not the same with respect to the office responding to the inventor. So examination, why? Because the moment you file your patent, your rights start. Your rights start there. But whereas when you have to do an infringement suit, then it is a 3 years from the date of infringement and not the date of grant. It's very important. Because all this needs to be really, it's a sublimation of everything. We can't leave that let alone kind of thing. So now when I consider, again, back to this particular aspect of a patent filing, the day you file, your priority date is that. So your rights don't start. You can't initiate an infringement suit only when you get it granted, you can, but your rights definitely start. So your priority date is the date when you're filing it. Then comes your objection removal and then examination before the patent, responding to the office actions and many other things, and then arguing it out before the controller. They examine it and then they respond and give it to you back, which means there are no set timelines, and this is a lacuna inbuilt in the statute. Because of which, that would be one of the reasons why I'm trying to say the timelines. I'm just trying to focus on what is the impact on timelines, because that's very necessary when we actually even consider that we've given Bolar exception kind of a thing as an amendment into the patent statute. So here I would say that, whereas if I say that patent examiners may be giving you a response later, and your time starts then, so your 20 years starts from the date of filing. So the later your examination, the more number of years you've lost. And this has happened in Elantoin or one particular drug a long time ago, where they had just 1 day as their monopoly term. Because of the reasons that there were a lot of objections, and by the time the examiners could respond and everything. So now what I want to say is your examination time is trying to eat out your monopoly term. But that's not definitely taken into cognizance, I would like to admit that. Here I would also like to make one more point, that whereas this particular thing of the aspect of a timeline comes into picture, now it's a 20 years monopoly. In consideration with a 20 years monopoly, that means that, say for example, you're having an innovator product, and an innovator product is in market. It will sometime fade away in terms of its exhaustion, in terms of its expiration term, so it will come to an end. When it comes to an end, what happens? Your monopoly term gets over. So your make, use, sell, offer to sell, importation of the rights to do all of that gets over as well. Another thing that happens is this product comes to the public domain. So into the public domain this particular product comes, and then the competitors are free to then use or probably do anything with respect to your invention, amend it, edit it, whatever it is, and sell it at lower costs, because India is a developing economy. We need to understand that. So considering the fact that India is a developing economy, it has to be more, because we are global players in terms of generics and biosimilars. We are the top leaders in terms of that. So considering that, the major chunk, around 20% of the shares of the generic market is Indian market. Why will India lose it all? It will be waiting. But the loophole is, by the time the expiration happens and the competitor wants to enter, the innovator company gives a clean check. That's not obstructing it. What is the obstruction? The obstruction is the regulatory approval, and there is where the Bolar exception, now I will be talking about it. The regulatory approval becomes tantamount. The regulatory approval in terms of putting the medicine and product out there in the market, in terms of authorization, only when you get it is when you can legitimately sell it. Otherwise, no. And hence, the time that is going to be lost in terms of, it's not a game, it's not an easy task, because you have to invest at least 2 to 3 years in accumulating preclinical, clinical data. because the regulatory submissions to get a valid authorization in terms of marketing will include efficacy data, safety data, everything. So when you have to get that, the preclinical, clinical trials and all of this needs to be completed, and it cannot be done overnight. Of course, forget overnight, not even a year. It takes a good 2 years, 3 years or whatever it is. It cannot be done because say phase 4 or phase 3 trials fail, you have to redo it. And that means you're going to edit it in terms of that. And hence, they came up with this factor that even before, when the patent is alive, before expiration, you are free to do that. But then started a lot of misuse of this rights, because exportation, because commercial. You know, when a lot of companies come and say that we did not, they said, okay, they have exported such huge quantities. Why do they need such huge quantities for research and development or for submission of an information in terms of a clinical, preclinical trials to be submitted to the regulatory authorities? What's the need? But there is nothing that prohibits. 107A does not talk about quantity at all. Whereas I would say in Bayer judgment, Delhi High Court said that yes, I mean, we are going to talk about, on one hand it says quantity is trivia, on the other hand says it's paramount and tantamount. And then they said that this is a list of things which needs to be considered when we are actually trying to take this particular exportation into consideration, or the sell, make, use, or whatever it is of in terms of the Bolar exception. So I think, so considering this aspect of to eat out the time and to be in market at the right time, because it's just not about one generic company who's suffering. Who is suffering? The public at large. Because we see endless patients there in the hospitals, and for the medicine which is worth so much amount, and when now is a happy day to actually celebrate it in terms of bringing a good product in market, what becomes an impediment is this, and Bolar exception was an answer to that. I'll just read out 107A. So let me know about the time. So that I'm not over time. What's the time?
2:55, 5 minutes to 7.
So till what time?
3:30. More than half an hour.
Okay. So 107, now also certain councils, I just read this page and this point came to my mind. Some councils or certain people who argue this matter would take this particular, and even the court would take this parameter into consideration, but how do they thrash it out? They say that since it comes under the title of defenses, etc. in suits for infringement, this particular thing also was brought up by the court, saying that no, it is not a subservient provision, it is an independent provision. Whereas the councils were arguing, since 107A wouldn't have been existent without a 48. 48 is the rights of patenting. Because of that, a 107 has come into picture. So now when they see this, that no, I mean, when we talk about, or when they say that when it's logically deliberated, the courts came up with the same thing that it's an independent provision. This is one. Defenses, etc. and suits for infringement, no. Because we'll say that section 48 is subject to other provisions. Correct? Because all of the provisions, and 48 itself says about the rights of the patent. It was thought about and deliberated and put down in the legislation on the statute book long time ago. So there is no scope. That means it is going to be, it is governed by other provisions. It's subject to other provisions. Whereas 107A, it is not subject to other provisions. Whereas 107A, I'm sorry, there's a slight confusion. 48, when we consider that with respect to other provisions, it is dependent on, it is subject on other provisions, and 107A is not dependent on because it was carved out later, and it rules as an exception criteria in the statute, in the patent statute, Indian Patent Act. Okay. Now when I consider defenses, etc. and suits for infringement, hence I would say that although the title of it, because 107 is divided into A and B, one which talks about parallel imports, that's B, and 107A which is Bolar exception, which is related to us. So when we look at it from this point of view, that defenses to suits and infringement and etc., no, it is not the case, and I'll explain to you why. Because in terms of certain citations and judgments, it definitely doesn't make sense that you can probably say that it can only be one of the. It is a defense, but it is not that because it is only a defense. It's a standalone case and a parameter and a provision which was carved out for the sake of many multiple reasons. 107A says certain acts not to be considered as infringement. For the purposes of this act, any act of making, constructing, using, selling or importing a patented invention solely for uses reasonably related to the development and submission of information required under any law for the time being enforced in India or in a country other than India that regulates the manufacture, construction, use, sale or import of any product. So I'll just read it in parts. Any act of making, constructing, using, selling or importing a patented invention. Now this is a right that is given to a patentee. Whereas 107 is different how? Further it says solely for uses reasonably related. So reasonably related was again thrashed out in Bayer. It was bought back in Merck Sharp and Dome again in 2019 and 2021 again. So reasonably related to the, how would you say what's reasonably related? So that was thrashed out in these judgments. To the development and submission of information required under any law for the time being in force in India. So submission of information means all that. Your dossier goes, your drug master file goes in terms of your clinical trials, preclinical trial data. So all the data goes to the regulatory authorities. It could be a US FDA there, it could be a DCGI in India, like that. So yes. So reasonably related to, so what are the important points to be noted? Make, use, sell, importation of a product, a patented product. Next is solely used for purposes of reasonably related to. Reasonably related, second point. Then, and submission of information required under any law. So submission or information which is required to be submitted to any regulatory authority for the time being in force in that particular country. Or in any other country other than India, this is important, or in any other country, any country other than India. This means it gives a clean room and space and freedom to operate in terms of a dead space which was created initially. Now that you can, because what happens, some countries would say that, no, I don't want to get it done in India. So API is what? An active pharmaceutical ingredient of a particular patented product in terms of a pharmaceutical product. This would also extend to medical devices. It would also extend to monoclonal antibodies and many other things. So we'll come to that. But primarily you would see that at least 80 to 90% of the litigation per se 107A which has been taken into consideration has been pharmaceuticals. And most of it has been argued in the terms of this because so many competitors. So you'll say day in and day out these kind of matters in terms of litigation which is arriving at High Court and Supreme Court. So, or in a country other than India is very important because that tells you that you can export the product. That regulates the manufacture, construction, use, sale or import of any product, importation of patented products by any person from a person who is duly authorized under the law to produce and sell or distribute the product. It shall not be considered as an infringement of patent rights. So I would want to say this. It is giving you a freedom from a liability of infringement because what otherwise would have constituted infringement. Infringement is what? It is seizing you, it's stopping a third party to attack the patented product and you're trying to put your foot on it and you're trying to tamper with it. That is infringement. But the moment you have a defense mechanism in place and you're trying to do that in terms of the legitimate authority that you have, then what you do is you try to make, use, sell and offer to sell, import, export, whatever it is, because now export also is come into the ambit. So whatever changes in terms of exceptions, then I'll come to also the patentability of inventions and exceptions, because that is also very important. So when I say that wanting to make a point here. Yeah, what otherwise would have constituted a violation now has given you the room and space. That is called as a freedom to operate, FTO. Because now it is as good as it is in public domain, excepting for the fact that you are trying to abide by whatever the exception conditions are. Reasonably related, quantity in terms of, you have to explain. So many of the councils would probably say that, look, they have actually exported 800 grams, it's not necessary in terms of a clinical trial or submission of information to a particular authority. What does the court say? File an affidavit, show us, burden of proof shifts to them. They say that show us that how you're saying it's commercial. Because you're trying to make a point that now it could be used for commercial purposes. Then in one of the cases, there was Bayer versus SMS Corporation or something like that, where both the companies were asked to file affidavits saying that we have not used it for commercial purpose. Which means now it is on record. You can't, perjure. So you have to be very sure about it, that yes, you have not done. So when, and it said that not just a statute, so exception is something where it is so larger and broader in ambit that a lot of things can fit in. But when it has to be fit in, either in terms of a precedent also you can do that. So it can evolve in terms of a case law as well. Now I go to 84, 90 and 92. Before that, I'll just say this particular thing. I should not miss it out, because see, it's such a, there's so many things in this. If you look at it, it may be as small, but if you look at it, it may be as big and huge and enormous. So, when this particular Bolar exception was included in the statute, they said, because TRIPS, so international instruments and national instruments, of course, both of it is governing this something, because this is not just related to your Indian domain. This is something which is spread across globally, because you are trying to also, because in terms of patenting, you enter the national face of a particular country, blah, blah, all that. So you're trying, because it's territorial, right? So in this aspect, there is a particular World Trade Organization, which deals with the trade of the world across the globe. Agreement in terms of TRIPS, which is trade-related aspects of intellectual property rights, was signed. There were member countries. So this member country now has a free hand where this is very pertinent to be noted. It's very important, because even the policymakers can't goof up in this aspect. So they said that you have a free hand in terms of carving out exceptions in terms of what could be an absentee from the rights of the patent holder. At the same time, you are not trying to disallow the normal exploitation of the patents by the patentee. So you have to see that you are trying to balance it out. So your policies could be good enough in terms of a larger margin that you have in terms of expanding the exceptions to a broader ambit to whatever, but you have to always keep a legitimate balance between the patent owner as well as the public policy, healthcare, everything. Healthcare I'm emphasizing more, because by now you would have understood that generic markets is what is considerably included in this particular talk on 107A. So whereas the TRIPS, that is Article 30 pertinently of the TRIPS, says that you have a bigger room in terms of exercising this time, leeway in terms of increasing the elasticity of the exceptions that is carved out. At the same time, you also have something else, that is, you have to bear in mind, you can't tamper with the exceptions of what could be patentable and what could not be patentable. These are two different things. You are not trying to say under 107A that this is patentable and that's not patentable. You're just trying to say what is an exception in terms of what could not be an infringement, in terms of the rights of a patentee. But at the same time, we'll have to always bear in mind that it is trying to restrict you in terms of the patentable subject matter. There you can't prohibit or include more or without reasons in terms of, and that's why we would see definitely that in 2 or 3 regions, in terms of the subject matter patentability, there you don't have much room. Policymakers don't have much room to actually explore much. So when we talk about US, when we talk about Europe, when we talk about India, so the scenario are different. I mean, in terms of what is a patentable subject matter and what is not a patentable subject matter. So what could easily, because it happens certain times. Glivec is one example where it got a clean sheet in terms of US, because here you have the patentable subject matter exceptions under Section 3 of the Patent Act, where Novartis's Glivec faced a problem, and of course they did not get. So on one hand you would see that something is not obtainable, so is it so difficult? At the same time you would see that, and so they would think the standards are high. No. Basically also when US tries to give it, I mean, in terms of having lesser exceptions in terms of patentable subject matter, and you're getting a grant there, you're not getting a grant here. So the idea is always bearing in mind, which is borne in mind by the national policy makers, that you have to actually cater to the drug price restoration. So that's very important. And hence, the lesser you allow to patent, the more it is in public domain. Got it? That way. So whereas there is an ease in terms of carving out more exceptions on 107A kind of things, or in and around 107A, there is a lot of impediments in terms of, or there's a lot of valves in terms of stopping the subject matter patentable inventions to be explored more. So there you have to be very wise in doing that. Okay, let's look at Section 84 of the Patent Act. Compulsory licenses, because this was one more, because there Bayer's versus SMS in 2019 had it was okay, let me put it this way. There were 2 ongoing litigations. Let me have this one first. Bayer had actually litigated against NATCO in terms of compulsory licensing, because they had, in terms of instead of maybe 6 or 9 grams, they had they got a clean sheet from the court of 6 or 9 grams, but then they later sought that they want to actually export around 1 kilogram. So then they had a round of litigation. In the meanwhile, there was also one more. I'll just refer to that. Can we later?
Please, you go ahead. We'll give you up.
Yeah. Okay, so Bayer Corporations' Union of India in 2019 were trying to construe the term exports. They filed 2 appeals, of course, and 4 injunctions and everything. So in terms of why are they prohibiting them, there was NATCO and LL.B Pharmaceuticals. I want to recollect that. So NATCO and LL.B Pharmaceuticals were included in this spate of litigation by Bayer, and for exporting Bayer's patented product 1, sorafenib, because that was the first and the last compulsory license that was given to NATCO, sorafenib tosylate. And but they forgot, and that is what happens when technically probably you do not have that much of information in terms of pharmaceuticals, how it works and everything. So they said that they understood and they misconceived it completely, because compulsory licensing has nothing to do with in terms of having to submit an information for regulatory approval or an information for the sake of regulatory approval. Whereas compulsory licensing is in terms of where you're trying to go down in terms of not trying to cater to the public interest, in terms of having the drug produced at optimum amount, not working it out. You're just keeping it idle. You are trying, which means you have the rights. If somebody does something, you're going to initiate an infringement suit. At the same time, you're not using and benefiting the public. That's why NATCO came up with that. And so they applied for a compulsory license under Section 84. But then Bayer misconstrued, saying, again, they talked about, because exports can come into picture and role mainly in terms of your 107A. And 84 is completely different. You are going to do that for commercial purposes. Well, so I'll just read out Section 84. At any time after the expiration of 3 years from the date of the grant of a patent, any person interested may make an application to the controller for the grant of compulsory license on patent on any of the following grounds. What? That the reasonable requirements of the public with respect to the patented invention have not been satisfied. Correct? That the patented invention is not available to the public at a reasonably affordable price. Second, I just said that in a just a while ago, that the patented invention has not worked in the territory of India. So you're keeping it idle. Sometimes it may be that, okay, they are there, but that is beyond the paying capacity of the middle income groups in India or any other nation which has got middle income to lower income groups. Well, an application under this section may be made by any person, notwithstanding that he is already the holder of a license under the patent, and no person shall be estopped from alleging that the reasonable requirements of the public with respect to the patented invention are not satisfied, or that the patented invention is not worked in the territory of India, or that the patented invention is not available to the public at a reasonably affordable price by reason of any admission made by him, whether in such a license or otherwise, or by reason of his having accepted such a license. Okay? So which means that we would see that here you're trying to make up for somebody who's faltering in terms of using his rights adequately, in terms of because nothing can stop. Even then, when there are certain particular provisions which gives government the rights to use a patent or to do something with respect to a patented invention, because of course they have a lot of free hand. So there are provisions with respect to that as well. But mostly you will see that the cited thing are mostly what? The exports and not imports. And that's why it became a problem area in terms of 107A. So in considering the application field under this section, the controller shall take into account the nature of the invention, the time which has elapsed since the sealing of the patent, and the measures already taken by the patentee or any licensee to make full use of the invention. The ability of the applicant to work the invention to the public advantage, the capacity of the applicant to undertake the risk in providing capital and working the invention if the application were granted. So of course, government is not going to be, or the intellectual property office is not going to be blind in terms of granting him the compulsory license, but he also has to fulfill certain criteria in terms of getting it. So it's very clear, I mean to say from the language of section 84, that it is no way prohibiting you from a commercial purpose. So Bayer's contention and argument was wrong there. As to whether the applicant has made efforts to obtain a license from the patentee on reasonable terms and conditions, and such efforts have not been successful within a reasonable period as a controller may deem fit. Like how we do in case of notice to be issued before you start any spate of litigation, like that. So similarly, have you tried it out of the court in terms of settling? And then you can of course go ahead filing an application that, look, give me a compulsory licensing because it is fitting into 84(1)(a), (b) or (c). And I am competent in terms of 84(6), 1, 2, 3, 4. Then I would also visit section 90. You can note it down if you want, like these sections are important. Terms and conditions of compulsory licenses. Because I said that it revolves around the exportation, selling, importation, everything. So I'm just trying to read that out because nothing misses. In settling the terms and conditions of a license under section 84, the controller shall endeavour to secure that the royalty and other remuneration, if any, received to the patentee or other person beneficially entitled to the patent is reasonable, having regard to the nature of the invention, the expenditure incurred by the patentee in making the invention or in developing it and obtaining a patent and keeping it in force, and other relevant factors. That the patented invention is worked to the fullest extent by the person to whom the license is granted and with reasonable profit to him. That the patented articles are made available to the public at reasonably affordable prices. That the license granted is a non-exclusive license and the right of the licensee is non-assignable. That the license is for the balance term of the patent unless a shorter term is consistent with public interest. Okay. Yes. 92A. Compulsory license for export of patented pharmaceutical products in certain exceptional circumstances. Compulsory license for export. This is why they argued what? That it is export in most of the provisions and not in this provisions which we're mainly talking about. So, compulsory license shall be available for manufacture and export of patented pharmaceutical products to any country having insufficient or no manufacturing capacity in the pharmaceutical sector for the concerned product to address public health problems, provided compulsory license has been granted by such country or such country has by notification or otherwise allowed importation of the patented pharmaceutical products from India. The controller shall on receipt of an application in the prescribed manner grant a compulsory license solely for manufacture and export of the concerned pharmaceutical product to such country under such terms and conditions as may be specified and published by him. So you see, in these two subclauses, export is very vividly come out. Then there may be certain more sections, of course I'm not getting into that right now. In terms of 107A, I just want to read out this particular thing. Which I already told and discussed. The Bolar exemption was recently revisited in India, culminating in a major decision by the Delhi High Court in Bayer Corporation vs. Union of India, which established an apparently open and flexible interpretation of the Bolar exemption. So it said this decision was based on Bayer's appeals on a single judge's decision, and it was versus whom? Natco and LL.B chemicals. There were writ petitions which were filed against Bayer, filed by Bayer against Natco and LL.B to prohibit the respondents from making, selling, distributing, advertising, exporting or offering for sale any product that infringed Bayer's patents for the drugs sorafenib and rivaroxaban. So I just wanted to say, these minute details of sorafenib is for the Natco in terms of compulsory license, and rivaroxaban is in terms of LL.B pharmaceuticals in terms of the exportation, because their rationale was they have exported it for clinical trials. So the contention was through the Indian Patent Office, Natco had already obtained a compulsory license from Bayer for sorafenib. Natco requested from Bayer to export around 1 kilogram. So it was 9 grams given court sanction, but they went on to 1 kilogram. They had to justify. Any which ways, but they forgot that in this case it will not be applicable at all, because as I just read out what compulsory license is all about, we will have these consideration in terms of the amount where it is for non-commercial purpose, where the non-commercial purpose does not fit into the ambit of compulsory license at all. Bayer denied the application and filed a writ petition claiming that granting Natco such permission would be in violation of section 107A, because the transaction involves a commercial activity and thus infringes on Bayer's rights. The court dismissed because they were trying to do what? Confuse on two different provisions. They said, you're giving compulsory licensing to them according to 107A, but how can you even read that with this as a court's opinion? So you can't read 84 with 107A. 107A is for what? Categorically, your exceptions carved to the extent of submissions for the regulatory approval. Natco is doing a service for the nation in terms of what? Coming up with a affordable drug for the sake of the public, which is underused, is not manufactured, or is silent in terms of keeping the patent rights with them without having been utilized. So the court dismissed Bayer's argument, ruling that section 107A covers any sale of a patented invention that is required for the development and submission of information under any law regulating the manufacture or sale of any product in a nation other than in India. The sale of 1 kilogram of sorafenib to the Chinese business was found to be reasonably connected to research that the company was obligated to conduct in order to secure regulatory license, and thus falls within the exception under section 107A. In both cases, the Delhi High Court's division bench issued a same ruling on the legal interpretation of section 107A of the Patent Act. So of course they also clarified this aspect of how a selling includes export. And then they came down with, now I'm not going into the details in terms of the dictionary meaning of sale and how territorial jurisdiction is not included in that, and so boss you cannot talk about it when you're talking about 107A, which also does not spell territorial jurisdiction categorically. The court cited a number of variables though. This is important, and this is what I was trying to say. On one hand, it definitely said that if we are going to consider this aspect of 107A, we will say that quantity, if you're going to talk about, is trivia. But on the other hand, it had 5 variables, and in that 5 variables, quantity of to be exported is one of the variables. So I'll just read that out. The nature of the patent awarded, the nature of the products or elements requested to be exported, the parties' details, the quantity of the product, and other data about the product's eventual use. So these were the ones. Of course, there were a lot of conflict in terms of what was probably ordered or what came through as a piece in the order, which was contradicting each other. But nevertheless, we are awaiting further judgments where probably there will be more clarity in terms of exports. So I think there is so much more, but then I think I'll have to stop in between, so it is better that I...
Take my mic. Thank you, Dhanalakshmi.
And I thank you very, very much. Before G.Seshagiri sir says many more things, I really appreciate all of y'all's patient hearing. I know it becomes really boring when it is a little technical kind of a discussion and everything, but I hope it was of use to you and aid to you. And I am really happy that this kind of academic sessions keep happening. And I think G.Seshagiri sir and all of you, they have done a very, painstaking efforts that they've taken and a very good job that they've done. Thank you so much to all of you.
Thank you, Dhanalakshmi. So nice of you. The way you explained patent laws, one can go through it, seriously. Thank you very much. You came all the way. You are addressing our Friday group. We are really appreciating your efforts and other things. You delivered very good lecture. And Harika will give a vote of thanks to this thing.
Good afternoon, everyone. On behalf of everyone here, I would like to extend my heartfelt thanks to Dr. Dhanalakshmi S. KrishnaIyer ma'am for sharing her invaluable insights on such a crucial topic like Bolar Exemption, how good a defense in patent infringement cases. Today we have been given the privilege to dive deeply into the nuances of Bolar Exemption, a topic that plays significant role in balancing the fine line between protecting IP rights and enabling progress in research and development, especially in pharma industry. Your thorough legal analysis of legal and practical implications has truly enriched us for understanding the complex areas of patent laws. So thank you so much, ma'am, for explaining us the patent laws. Secondly, I would like to thank you, Seshagiri Rao sir, who is the organizer of Friday group, who has given me the opportunity to give this vote of thanks to our esteemed speaker today. Thirdly, I would like to thank all of you for being so peaceful and patient and listening to our esteemed speaker, Dhanalakshmi ma'am. Thank you so much.
Thank you, Naharika. Very nicely explained vote of thanks. So as youngsters, she is with Dr. Sridhar Potharaja's office, recently joined, youngest member, and further Madhu Yadav also.